Hi, this is Jonathan Ginsberg. I'm a Social Security disability attorney. And today I'd like to talk to you about my experience at a hearing, which I tried today, in a rheumatoid arthritis claim. And my client was a very credible witness. She had a long work history at a skilled occupation. She clearly did not want to stop working. She tried to work even after the doctors told her to stop. She tried but could not do it, and finally had to resign in the middle of a project just because she simply could not continue to function. And her primary impairment is rheumatoid arthritis, and this is a condition in her case that had developed when she was a teenager, and it kept getting worse. And she's now 48, and the last 3 or 4 years, it got to the point where it moved from her feet and knees, where it was more or less manageable, into her back and hips, where it became really too much for her. What was interesting is we had a judge, a very reasonable judge in our case, and when I look back on my notes, the questions he was asking her, and I asked most of the questions, but he did have a few, he was focused really not so much on pain. He was really focused a lot on postural limitations, bending, stooping, climbing, reaching, things like that, ladders, ropes, scaffolds. So he was really focused on her physical capacity to move around and to reach and to handle. He asked a lot about her grip strength, and was she dropping things, and her ability to hold a pen or to type. He asked her about her lifting and tried to, elicit testimony that her lifting was limited to 5 pounds or less. He talked about medication side effects. She's on methotrexate, which makes her nauseous for 2 or 3 days after she takes it, and she takes it by injection once a week, but he focused a lot on that. He focused on the need to lie down and rest every 2 or 3 times a day. Fatigue, or to get the pain and stress off her back, was a big issue. And he did ask her a lot of questions about her work history, and really seemed very impressed about her long work history. But if you notice what's missing, even though she testified my questions about a significant level of pain, and how her pain was moving from one part of the body to the other, and how even if she got one part of the body under control, another part would be bothering her, the judge really didn't ask about pain at all. And in his question of the vocational witness, he really talked about functional limitations as opposed to pain. Pain is what they call a non-exertional limitation, because it's obviously very subjective in somebody's mind, but the judge really did not talk about pain at all. So I thought that was really kind of interesting. So in rheumatoid arthritis cases, I think one of the things, you shouldn't not talk about your pain, but I think that when you're looking to testify to the judge, really think about and focus on the limitations you have in terms of your functioning, both your physical functioning, in terms of your hands, your feet, your back, moving around, that sort of things, as well as some of the, even though pain is part of this, but some of the non-exertional limitations, problems with concentration, fatigue, need to lie down. And obviously you can talk about pain, but I think that the judge was maybe moving away from something that's inherently subjective to something that's a little bit more measurable, that is consistent with what the doctor had in my client's case, a rheumatologist, her report. But pain was just not a big part of it. So I'm not sure if that represents a trend or some sort of a effort by Social Security to focus less on pain. But I know certainly in the fibromyalgia realm, which is essentially a pain condition, those have become much more difficult to win. My guess is that Social Security is telling the judges, if your clients, if your claimant rather focuses primarily on pain, there needs to be an objective source about it, but look more at the functional limitations as opposed to the subjective element of pain. So that was my experience in that rheumatoid arthritis case. There was also, by the way, some stenosis, some back problems. So there was a lot of physical issues that gave rise to a lot of pain, but again, very little discussion of pain on its own during the actual hearing. So I thought that was kind of interesting. I thought I would share that with you. If you found this helpful, I encourage you to give me a thumbs up on YouTube, like it on Facebook, subscribe to my YouTube channel, and like our Facebook page. Leave me a comment. Let me know what you think, what your experiences have been. Have judges focused on your pain? How does your pain limit your capacity to work? Maybe we can share some ideas here. And again, if I can be of help to you, please let me know. Visit my website at ssdanswers.com, and you can download my free Secrets to Winning Disability Survival Kit. A lot of good information there. And again, if I can be of help, let me know. This is Jonathan Ginsberg, wishing you the best. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the Survival Kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.